In an impressive display of rage, YouTuber and sometime homeless activist Regan Benson responded to her loss for a preliminary injunction in her lawsuit against the Denver Police Department, released an extended statement on her YouTube community page about the development. Benson was seeking said preliminary injunction to force the Denver Police Department to consider her for a civilian role on the Use of Force Board. Civilian members are typically nominated by police staff for consideration on the panel. As Benson was unable to secure a recommendation, she contacted Commander Hans Levens, who oversees Denver's Conduct Review Bureau, and Commander Joel Bell, who is in charge of Denver's District 3. Both men told her that she would not be nominated for a position on the board, with Levens stating that it was due to her past history with the Denver Police Department, then later clarifying it was because they felt she was biased against the police. That designation was apparently based on interactions with her, which showed that she could not be impartial in her dealings with the police, especially on a sensitive board where officers' futures were determined. Benson sued for injunctive and declaratory relief, along with financial and punitive damages, claiming she suffered permanent damage and that her First Amendment rights were violated by not being considered for the role. The preliminary injunction was a key part of the lawsuit, as it was Benson's attempt to force her way into consideration for a position on the board. The hearing was scheduled for Friday. No official paperwork has been filed in Pacer to reflect the outcome of the hearing. Benson released her own take on the hearing, however, which we bring to you now. The picture? That's Ron Thomas, the chief of the Denver PD. He lied on the stand yesterday under oath. He didn't do it very confidently either. Another cop on the stand, Commander Hans Levens, Office of Conduct Review, he lied on the stand too. He didn't do it very confidently to begin with, but once he found his rhythm, he flowed like a well-oiled machine with confidence. His boss did it. Why didn't he strive to do it better? Commander Joel Bell and Deputy Chief Aaron Sanchez, they were also subpoenaed to testify. They are such worthless tools, even for their boss. It's barely worth mentioning their presence and testimony. Here's the summary for that. It was 6th grade recess entertainment. Read on for more about me, the peasant, losing against the government's army in my preliminary injunction yesterday. We've made it this way. When you take on your government in this civilized country in a quest for truth, accountability, and justice, you're going to lose more than you're going to win. That is a guarantee, if you're being honest about what grassroots activism costs one in totality. In fact, you may never win. People have paid with their lives in this country simply because of their speech. One must fully evaluate and be their own judge, jury, and executioner on what is worthy for the win column. That can mean many different things to different people. Nonetheless, it's a scary proposition, and it is a gamble. We've made it this way. Activism for truth, justice, and a desire to help ourselves or others whom have been wronged and harmed by our government is also a scary proposition. It often comes with arrests and jail. It can come with a physical toll on your health and your life. Turning on your cell phone camera and pointing it at government has a myriad of implications. This isn't about starting a YouTube channel on the simplicity of anybody can do it. That couldn't be further from the truth. It has to do with serving a greater calling in one's civic duty to serve others without subscribing to a government paycheck. That makes you public enemy number one with many people that are deliberately ignorant in preservation of their own rights, let alone others. It also puts you on the government seek and destroy list of undesirables. The methods of how that happens vary. The vast majority of government workers, judges, politicians, etc., are members of a literal legalized theft by deception program because there is no accountability. It's called forced taxation. Again, we've made it this way. For me, it also has to do with paving what is supposed to be a continued, clear, and wider path to living free in a free country, which in turn is supposed to serve my kids and grandkids better than their previous generation headed. But because we've made it this way, that path is narrowing, and it's not much of a path anymore. It's a field of landmines. The question is, how long will civilization of a civilized nation survive it? People fear this government. Fact. That is the definition to tyranny. We are way beyond right versus left, and if you're still contemplating and formulating an argument for that concept, you're way behind in your comprehension of history lessons. This free country is in big trouble and not on a good trajectory. The only real deniers of this fact are those collecting a government check in various delivery methods and those benefiting from that check. The following are my opinions only and not a legal analysis. I'm not an attorney. I don't form legal analysis. The Denver PD has been reaffirmed by U.S. District Court Chief Judge Brimmer, appointed by Bush in 2008, that their secret non-public forum meetings, use of force board, that discuss the details and findings of its department unaliving people in Denver, should continue operating in secrecy. Not only should they operate in secrecy, but the judge helped them continue their efforts to ensure people like Regan Benson don't ever interrupt that process. Judge Brimmer, as he read in his ruling, in my very strongest held opinion of what he did, provided the DPD with legal advice to help them rewrite their policies so that they never end up in court again for the blatant First Amendment retaliation they displayed in this case for silencing my speech in a public process to apply for the Force of Use Board. He also assisted Denver PD command structure in solidifying his ruling based on the facts of the case by simply stating, in paraphrase, "I find the cop testimony credible." Judge Brimmer entirely ignored my attorney's objection and clarification to the less than 30 seconds of video played by the other side as an attempt at deflection from the issue and full-on intent to persuade the judge as facts of the case, and instead of the judge crafted his own narrative to document facts of the case using that video. Side note, this is why attorneys want you to appear polite and respectful with the police, because juries and judges are against the First Amendment and signed up to destroy it at the end of the day. Well, that's not me. I don't negotiate respect with tyrants that end lives on the spot with impunity. You'll get what you give times 3 from my mouth. The judge came into yesterday's hearing with his own lack of impartiality, his continued statements about me, and his predetermined ruling. It's what they do. He knows how to attempt to make himself appear above water and secure his ruling. For somebody trying to convince me that this is real court, not the kangaroo courts I'm used to, this was by far the #1 kangaroo court experience for me to date. There are some other things that Judge Brimmer stated as facts of the case that will forever be etched in my mind. I can't tell you what the #1 most rewarding thing was that the judge said for my personal win column, because if I tell you, I'll be aiding future representatives that are being paid with your tax dollars to help bad actors in government avoid accountability. But I will tell you my second most rewarding thing for my personal win column that the judge verbalized in this federal courtroom, where you could hear a pin drop. As the judge continued assisting the government's army by reading into the record the facts of the case, it seemingly could be described as a very slow and different tone of voice when he reached this juncture of what he was about to say. He read the title of my video played in his courtroom in full pronunciation of every word. Check these effers out. We've made it this way, Regan Benson. We'll update this story once the official minute notes from the hearing is released. An update, both Benson's motion to exclude evidence of any police activity she's been involved in after February of 2025 and her motion for a preliminary injunction were officially denied. The case has been referred back to the magistrate judge for scheduling and discovery issues. Order referring case to Magistrate Judge Catherine A. Starnella for non-dispositive matters, pursuant to 28 U.S. Code Section 636B 1A and B, and Federal Rules of Civil Procedure 72A and B. This case is referred to the assigned United States Magistrate Judge to convene a scheduling conference under Federal Rules of Civil Procedure 16B and enter a scheduling order meeting the requirements of District of Colorado, conduct such status conferences, and issue such orders necessary for compliance with the scheduling order, including amendments or modifications of the scheduling order upon a showing of good cause. Hear and determine pretrial matters, including discovery and other non-dispositive motions, and conduct a pretrial conference and enter a pretrial order. Court-sponsored alternative dispute resolution is governed by the District of Central Colorado Civil Rules 16.6 on the recommendation or informal request of the magistrate judge or on the request of parties by motion. This court may direct the parties to engage in an early neutral evaluation, a settlement conference, or another alternative dispute resolution proceeding by Chief Judge Philip A. Brimmer on December 8, 2025.